Hello, I'm Matthew Graham, the Pro Bono Coordinator and Supervising Solicitor at the University of Law in Manchester. And today I'm going to give you a session on legal research and letter writing. So a few tips on research and how to present that research, and then some tips on letter writing, including writing style and things to avoid, and also what I consider to be the golden formula for the advice section of a letter, which also equates to a formula for answering questions in an exam too. So points on legal research. First point, don't use Google. Of course you will. It's the temptation is there to use Google, but the reason not to is because what you will come across could be written by anyone. Accuracy can't be, you can't be sure of the accuracy, and it can't be trusted. Even government websites can't always be trusted. Even government legislation isn't always up to date. So my first tip on legal research is to use either Practical Law or Lexis PSL. Personally, I really like Practical Law, and the great thing about them is that the search bars that they have is pretty much like Google. They've really worked on it so that you can just enter terms, generic terms, and it will come up with really good hits. So the Practical Law has something called practice notes, and Lexis PSL has something called an overview, and that gives you an overview of the area of law that you're interested in. Sometimes they're quite long, sometimes they're fairly short, but it's such a wonderful thing. It's clear, it's simple, up to date, and I really do find them excellent. They also link to other practice notes that might be useful to you, and link to cases and other commentary. So you should be able to find out everything that you need to find. As far as research skills goes, what I would say, if you need some help on using those particular databases or search tools, the library at your educational establishment will no doubt have some guidance, and you might even be able to book a session with the librarian to show you how to use that. Also, LexisNexis and Westlaw, they do have things on YouTube and other helpful hints, so you could have a look at those too. Presenting your findings with regard to legal research, what I would say is that, certainly for me when I'm supervising in the clinic, I don't always know the answer to the client's question, and even if I think I know the answer, I always want it to be supported by evidence. And when I say evidence, I mean a reliable database or legal source, not Google. So if you are doing as I advise and getting an overview either from LexisNexis or Westlaw, download that into a Word document. Particularly Westlaw has, when you do download something, try and save it, it saves it as an RTF, which is a rich text format, which is a bit annoying, and you have to remind it to save it as a Word document. But if you do save it as a Word document, there's more you can do with it. And again, download any relevant cases as Word documents, download the case summary, and if necessary, the full text of the cases, if necessary. Thing to do is to, now it's in a Word document, you can highlight any parts that are particularly relevant. So a lot of the overviews, as I say, they might be 14 pages long, but because they're so well set out and so well set out with headings and sections, you know that you can ignore some parts of it. You know that you can skip some parts of it, but you know that some parts of it are going to be particularly relevant to your client's particular situation. So what I would say is highlight the parts that are relevant to your client's particular situation, so you can find those easily again, and also your supervisor can find those very easily too. You should save or print that document for your client's file. So if you've got paper files, obviously print it. If electronic files, save that as well. And that is to justify the reason that you've come to the conclusion that you've come to. So it's on the client file, and if you had to look backwards, you would understand why you've reached that conclusion. As far as writing up the research goes, the form should take whatever form you've been taught, either at your institution or in your clinic. There may be a prescribed form that you should use. But what I would say as well is, going back to what I've just said about your supervisor not always knowing the answer, or at least wanting reassurance as to what that answer is, make sure that you attach your research as well as whatever research note that you provided. So if you've downloaded, as I suggest, a Word document, and you've highlighted the relevant parts, that's really going to help your supervisor to understand what conclusion you've come to. So on to the actual writing of letters. This is a quote from the Plain English movement in the United States. Lawyers have two common failings. One is that they do not write well, and the other is they think they do. And I think that can be true, certainly for a lot of lawyers. And I think it is getting better, particularly if you look at conveyancing documents, for instance, are from beginning of the 20th century, are really, really difficult to understand and use a lot of legal words, but there's been a movement away from that, and things are getting better. But here is an example. It's quite easy to when you're writing a letter to a client, to fall into a sort of mindset of a bit like your telephone voice, your letter writing voice, and you feel sometimes that you have to make things a little bit more grand, a little bit more formal. And I'd say this is something that you should avoid, particularly in clinics, I think, because a lot of clinical work is dealing with clients who are don't have much legal understanding and might well not be brilliant with English. English might not be the first language, and reading letters, generally speaking, might be quite intimidating for them. So I would say keeping it simple is really, really important in clinics. But here's an example. So if there are any points on which you require explanation or further particulars, we should be glad to furnish such additional details as may be required by telephone. Instead of that, all I needed to write was, if you have any questions, please phone. And I think it's really important. One thing that I'm always impressed with, with a good book or a good judgment, if, for instance, Supreme Court judgments, they're brilliantly set out. They are really well structured. Don't use language that's unnecessarily complicated, and you can follow it. And we should aim for that within our letters, perhaps not quite as technical as a Supreme Court judgment, but we should aim for something that should be understood by all within our letters. So here's a few things to keep in mind. Is to keep it short. Sentences shouldn't be 2 or 3 clauses. Any more than that, and it's too long. Paragraphs should be short and to the point, and grouped in a way that makes sense. This is something that happens a lot in the letters that I review. There's a lot of padding, and it goes back to what I was talking about before, sort of your telephone voice, your letter writing voice. But a lot of the time, it's just not needed. So for instance, in the circumstances, you don't need to say that. Of course, it's the circumstances of a client, or in this instance. And my personal bugbear is the law says. You're writing a legal letter of advice. They're trusting you to know what it is you're talking about. You do not have to qualify what you're telling them with the law says. And it's a clunky phrase anyway, but you just need to tell them how it is. You don't have to say anything more. Another thing is to avoid tautologies, and a tautology is saying the same thing twice. So, giving some examples here. So, an unfilled vacancy, it's a vacancy. True facts, well, arguably you can get false facts, but in the current climate. And now current, obviously you're saying the same thing there. And avoid, again, excessive adjectives. Careful and detailed consideration, and grave and fatal error. So these flowery languages. It's extending your sentences where it doesn't have to happen. A letter of advice, especially with the clients that we probably have in mind, is not the place to start using flowery language. It is to the point, and it is simple and easy to understand. Another thing that helps with keeping things simple and easy to understand is to use the active voice where possible. So the active voice is the defendant struck the claimant. So you put the subject first and the object, that's the claimant, second, and the verb in the middle. So defendant struck the claimant. Whereas the passive voice, which is something to be avoided, is you put the subject, the claimant, was struck by the defendant. It is just a bit more complicated, a bit more less direct, and being direct is what we want in this instance. So layout wise, with regard to letter writing, your clinic will have its own style and have its own headings that it wants to include, and you should be guided by that. But what I would say is a rule for all letters is that, as I mentioned before, they should have proper paragraphs, proper headings to those paragraphs if it's appropriate to do so, and bullet points again if it's appropriate. I think it's a good way of expressing things succinctly. Consistent formatting, that's another bugbear of mine, is that all the spacing should be the same, all the indentation should be the same. And if you need some help and guidance, ask your supervisor for an example letter of how it's normally done in the clinic. And each clinic will also probably have its own house style. So that means spacing, whether it's double spaced or 1.5 spaced, a font size and a font type, so Arial size 11 for instance, and a particular way that they want the dates to be set out. So in my clinic, for instance, we write them out in full with a simple number. 21 June 2018 would be how it should be set out consistently throughout the letter, and not 21st or in numerical format. So most letters of advice will have a background section. And that's a section that records what your client has told you, as well as what you might have gathered from the documents. It does two things. It tells your client what you've understood from their situation, so that your advice is based on that understanding. And it also really helps to focus the mind on what needs to be looked at and what needs to be researched and what the issues are. It's often quite a difficult thing to do because you will get a lot of information from a client, and the client is often quite stressed and doesn't understand what's necessarily relevant, and because of the stress and emotional involvement will tell you the things that have affected them emotionally, which I'm sure you'll hear in your interviewing parts is important to listen to, but it doesn't necessarily need to be recorded. So in the background section, so make it succinct and avoid any repetition. And in the background section, don't put any law, put only the relevant facts. I think it's an important thing in the background section to record information that's missing. So as I said, this is you telling the client what you've understood of their position. And if you don't know something, then you need to tell the client that something is missing. So for instance, I've put, you do not provide details of the date that you separated. It might not in the end of it be particularly important, but it is worth recording if you think something's missing, and certainly if it's going to be relevant, if separation in this instance, if it was about a property dispute, then the date that they moved out would probably be relevant to the advice that you gave. The background section sounds like it's obvious, but often get letters where the order is not chronological. It doesn't follow. It tends to follow the way that the client has sometimes told you the story, and that can often be backwards and forwards as things occur to a client, or just as how it sits in their memory. But when you're writing a letter, it needs to start from the beginning and end up to date. Quite a good trick to do in the background section is to define a noun that will be referred to many times. So in this instance, if it's an advice about a lease, you're going to refer to that lease lots of times, and maybe other leases that get referred to. So if you say on the 5th of April 2018 you sign a lease, and then in brackets you put the lease in speech marks, every time that you refer then in that letter to that lease, you just put lease with a capital L, and that makes things much more simple. And again, if you don't know dates, try to place it somewhere. Often you can develop this from a client. If you've not managed to pick it up from the documents, you can ask the client to give you a view of when they think that might have occurred. So around May 2018, you telephoned your landlord. Coming back to what I said earlier about the emotional stress that a client is under and the difficulties they may have faced, I think it's a good idea in a letter to record the effect on the client, so that you kind of acknowledge that the difficulties that they've been having, and should I say, even more importantly, possibly to record what the client wants, what outcome the client wants, which I'm sure you'll do at the interview stage. But it's very often that you will hear a full story from a client and still not be entirely sure what they want to achieve. There's many different options for them, but what they want to achieve is so important, and that should also be recorded in the background section. So, for instance, you found the situation stressful and want to know whether you can resist the proposed rental increase in this example that I've put. Also in the background section, I think you should always record what documents has sent you with the date first. So in this example, it would be 5th of April 2018, lease 12th of April 2018, notice from your landlord to increase the rent. And again, that's showing the client what documents you've had and from the basis of your advice is given. So in this section, I've got some information from a theoretical situation from a client that we've received. And what I want you to do is pause the video here, have a look at this, and see if you can write a background section, bearing in mind all the things that I said on the previous panel. You might have to go back for those sections, but to chronological order, put the dates first, all those kind of things. Only try and put the relevant information, and see if you can have a go at that. Pause the video, have a go at that, spend 5 minutes having a go at that, and compare it to the next slide. So here we go. The next slide shows how all the dates are first. The issues are separated. There are estimated dates where dates are not known, and at the end, the last thing that's been recorded, you're deeply stressed by the post and you'd like a public apology. So the impact and the outcome that the client would want. Again, you can just pause that and have a look at that and compare it to the one that you've done. I shan't linger on that any longer. This is the most important part, probably, of a letter, is the advice section, of course. You need it to be accurate. This is a method which I call the golden formula, which is perhaps a little grand, but it's a formula that I really encourage students to use, not just in letter writing, but it helps approaching an exam question too. So there's 4 steps I think that every good letter and every good answer should have. And the first step is to state the relevant law. So in a letter, you'll be stating what the law is, what's the basis of the law. And in a letter, you don't necessarily want to tell the client where that comes from. They don't necessarily need to know. Depending on the client, you might get some clients who've got some knowledge, who've done a bit of research themselves, and it might be worth telling them the source of the law, the relevant law. And certainly in an exam situation, you need to show the examiner you know where that came from, whether it be a case or whether it be a statute. The second step is to summarize the relevant facts. So this focuses again your mind on answering the question, and also reminds the client the relevant facts of their situation that you're going to apply the law to. The third step is to apply the law to the known facts, and we're going to give an example in a second, so it's not all theoretical. That's the difficult part, to try to, in both an exam and in a letter writing situation, is to try to think about the client's situation and to apply what you've researched and your understanding of the law into that situation. That's where supervisors come in. That's where experience comes in. So if you need help on doing that, I'm sure that your clinic supervisor can help on that. And then once you've applied the law to the facts, to conclude, and that's usually just a sentence or two, and I'll talk about that too in a second. So this is a practice. This is just something to pause and to look over, and it's using the same facts that we used a second ago with regard to the theoretical defamation case. But this is how the advice section of this particular letter would look. So we state the law at the top, and we talk about the Defamation Act and everything that includes, and also case law thereafter. The courts have set a high threshold for the interpretation of serious harm. Second step, to summarise the facts. So we were talking about Mr. Smith made comments that he plagiarised his work, but then talked about other significant matters. That's just the facts, and then applying the law to the facts, whatever their nature, because so few people would like to have seen the post and they were not known to you. We consider it would be difficult to prove that you suffered serious harm. And then separately, there's a second issue to do with a second incident, basically. And that again repeats summarising the facts and applying the law to the facts, those facts, and the law according to those facts. And finally, the conclusion is both parts. On the evidence we consider, your prospects are poor. But again, I hope that makes sense. That'll make more sense if you've done the exercise beforehand. But it gives you an example of how you would state the law and summarise the facts and apply the law to those facts. The advice section, the conclusion in the advice section. So, especially with clinical matters, we tend to get them quite early. I'm speaking for my clinic anyway. We tend to get them quite early in proceedings, and on that basis, you probably haven't had all the information. But even where you have, even in practice, the conclusion part, the advice to a client on their prospects of success, are always fairly qualified. As I say, lawyers are normally fairly circumspect, so avoid stating matters as a certainty. There's always, in any case, you've still got to persuade the judge on the day that your information is correct, come across as, if his witnesses involved, come across as credible, and that's not a given. So it's communicating, especially to a judge who's only got, say, a couple of hours to try to absorb everything, doesn't necessarily mean you're going to win. So you qualify all advice on that basis. And there's a couple of phrases that I often encourage students to use. On the current evidence, we consider your prospects, or whatever they are. Or if you can prove that, there's quite a good way of being quite assertive and quite positive for a client. If you can prove that your employer discriminated against you as you described, you are likely to be successful. So that's quite a good way of other things to consider in letters. As I say, your clinic will have its own format for letters, but time limits are always really important. Relevant statutory time limits. So employment law, often there's very strict time limits of 3 months to bring, for instance, to bring a claim for unfair dismissal. Public law, if you're bringing a claim for judicial review, again, there's very strict time limits. Again, I think it's 3 months. And contract and tort have their own time limits too, usually 6 years to bring a claim. But for personal injury, it's less than that, it's 3 years. I think it's 3 years. Don't quote me on that. It was 3 years back when I used to do it in practice. Another part that you might want to think about is the summary section. So if you've got a very long letter, it's often useful for a client who's really trying to understand where the position is to do an executive summary or a summary section at the beginning. just to say our letter's long and all our reasoning is set out here, but this is the headlines of it, and just give them the conclusion or the advice part of it. And another thing that I like to add in my letters is a next step section. So whatever the advice may have been, practical advice that the client can use to try to move the matter forward or to conclude the matter. Often, yeah, negotiation, or if it's a litigious matter. Again, you should liaise with your supervisor to try to think about that practical advice, because experience will give more options than purely legal ones. Sometimes the practical advice can include sort of non-legal but more practical advice. Just a note again on writing letters, drafting letters, and dealing with your supervisor. Just notes to manage your own time and to try to be clear on when you're going to do the work and what you're going to do. Try to overestimate. Often drafting letters takes a bit longer than you might estimate. Consider your supervisor's time. If it's an external solicitor, they might be working full time with their own caseload, or if it's internal in the university, they're also going to have demands on their time. So just bear that in mind. Bear in mind that if a letter is due out on the Friday and you send it to your supervisor on the Thursday evening, it might not get out on time. You need to try to agree beforehand deadlines for all these things to happen. So stick to any schedule that has been agreed. And anticipate delays. You know your own the demands on your time, and there are many demands on your time. It's not easy studying as well as volunteering, and you've have to have a social life too. So do anticipate delays and negotiate, as I say, any extensions that you need. And communication is so key. So if the deadline is approaching and you feel like you're not going to achieve it, communicate that early. Try to agree a different deadline when it needs to be removed. And I say that with regard to talking to your supervisor, and however the communication with the client happens to. Clients are usually quite agreeable if a deadline has to be moved. So just communication is key in these kind of relationships. But I would say also enjoy the experience. I particularly enjoy writing the initial letter of advice, reviewing the file and sort of getting to grips with it, and giving a client a definitive view, definitive with the qualifications that I've talked about, as to what they can do and to give the next steps. So it's very satisfying, I think, to do that, and it is a great help to the client. Moreover, it's a fantastic way for you to improve your writing skills, to improve your analysis skills, research. It's always good to get the experience to do that. And you should reflect on what you've learned within that period. It's not just a question of box ticking. Yeah, I've done a letter of advice, I've been involved in clinic, I can put that on my CV. Employers want to know what you've learned from that experience, not just that you've done it. So do reflect on what you've learned. But once you've reflected, you can use those examples for interviews and for applications. But do bear in mind, obviously, client confidentiality, and anything that you do relay should be anonymized completely. Thank you. I think that's it. I hope that's helped, and I hope you enjoy the experience in the year going forwards.